Good evening, everyone. Thank you, Dolphy, Dista, all the organizers. It's actually a very tough task after to speak after your senior or your eminent senior has spoken. Generally, the courts don't listen to the juniors also, but I'll try my best to touch some of the things which Vrinda has left to me to touch. First of all, every time this government does anything, it puts us in more confusion why they have done it. What is the reason they have done it? Is there something sinister because they can't do anything straight? They have no goodwill to do anything. Whether it's the farm laws, there are any other laws they have taken, there is something sinister. But in criminal laws, because as Vrinda said, they had this consultation when people were dying because it was in the middle of COVID. There were bodies flowing, and we in the evenings on every Sunday were sitting and discussing because that was also important because what they are going to do with the live people who are not going to die because of COVID. So we decided to participate and deliberate. And middle of that, many of the lawyers' families would fall ill. They would join back after many weeks. And this was the process that they had, which shows that there was no seriousness in the process. If you expect people to put their minds in middle of a pandemic, there is no seriousness to this process, and we don't know. So when you go through these laws minutely, then you realize what the plan is, what the sinister ideas behind they have to bring in these laws. At one level, you see that they have done a copy-paste job. Decolonization, there is no decolonization. Because if there was decolonization, the laws should have been more humane. You are an Indian government now, you say that the British has left with these laws, we will make laws. So what kind of laws you will make? You should have made more humane laws. Reduce the punishments. Death penalty should have gone. Marital rape should have been introduced. These are the things they should have. None of these things are there. And what they do, I will point out few of the provisions, how they are harming, going after the people, but there is a confusion. Neither they want to go after the complainant's rights, nor they want to go after nor they want to help the accused rights. But there is a plan to bolster the state, take more powers from the people, and that is the sinister plan they have. These laws, if you go to see, seem to be more draconian than what the British brought the laws. And one will realize at some point of time, probably they were better. You come back and make laws, somebody will say to them. And these laws are not accepted to us, though it is done by an Indian parliament. Now I'll give you some of the examples. Vernon is here and he knows the discharge applications in his case are pending for last 6 years. 6 years have passed, no discharge application has been decided. Out of 18 people, one person's discharge application has been decided. And now the courts, the new law says the discharge should be decided, filed, not decided. Decided, there is no time limit. But the moment the accused gets a copy of the charge sheet, the accused has to file a discharge application within 60 days. What is the logic? Nobody knows. Apart from curtailing the rights of the accused, many accused are illiterate. They don't have lawyers till the trial starts. They don't understand what is there in the charge sheet, what is not there in the charge sheet. Now they also have a same time provision to produce them through video conferencing. So these accused may not be able to meet their lawyers and know who are their lawyers, who the family has arranged as a lawyer, and they expect the discharge applications to be filed within 60 days. First 60 days they can take police remand anytime. Time limit for filing the charge sheet is 90 days. But the discharge application, moment they get the papers, has to be filed within 60 days. If anybody has seen the Bhima Koregaon charge sheet, it is more than 10,000 pages.
Good for you.
I have not read all the 10,000 pages. I'm very, I'm representing one of the accused, so it's impossible to, when you give these timelines.
Yeah.
And let me give an example. When we started working with India Center for more than now 2 decades ago, my work was going to jail and taking up cases of people who can't afford lawyers. The two cases I will tell you why discharge without a timeline is important. There was this case of Johnny John, or who was called David. He came from Kolkata and was living on the footpaths in near Matunga, Sion. One fine day he gets arrested, and because they also have misused DK Baisu guidelines, they said there were 18 cases between Sion and Matunga police station pending of car tape theft. That time there used to be car tape theft. So as per the DK Basu guidelines, the control room is informed one guy is arrested for car tape theft. So both the police stations together put 18 cases on him. He's arrested. After the 17th case, he has slashed his wrist because he's tired of police custody. He's tired of the constant torture in police custody. And finally, the magistrate grants him judicial custody. He is sent to jail. We as lawyers, young lawyers, went to jail and met him after 11 months after the charge sheet filed. First he said, well, we asked, where are your papers? साहब मेरे को बहुत गुस्सा आया तो मैंने सारा पेपर जला दिया. That was his response. Okay, we get the papers. After it took about 3 months to get all the papers. In all the charge sheets, there was the same car tape which was put in 18 cases. He was discharged in 18 cases. And this was after a period of 1.5 years. And today they are saying you file the discharge application in 60 days.
Yeah.
The second case, I still remember, is of one woman close by from Dharavi, Fatima. She had gone to Dubai, earned for some work there, earned money to basically to have a good wedding for her daughter. She comes back, police want the money, some money from her. She refuses to give. One fine day, she is arrested in a murder case. And she doesn't know. For 2 years, she was 2 years in custody. We meet her in jail after 2 years. We see the charge sheet, there is absolutely no evidence. We point out to the Sessions Court, there is no evidence. After 2 years, she is discharged from the case. And today they are saying file it within 60 days after you get papers. And there is no explanation. As I said, there is no logic to what they do. It's completely ridiculous. And let me tell you a fun fact also. The Home Minister filed his discharge application after 6 years. Rest is history. A judge changed, a judge died, and the Home Minister got discharged. I'm not saying anything more. I'm just saying, giving you the facts. So, and these laws have come from the Home Ministry, which should have come from the Law and Judiciary Ministry. This has been tabled by the Home Minister. This is his baby. At least he should have seen that provision that I could not file a discharge application in 60 days. I took 6 years. But no. As I said, there is no logic to what they do. Then, there is a new provision. It's understood if the accused doesn't come before the court, you cannot proceed in a trial. But there is a new provision. Trial can happen against a proclaimed offender. If an accused is not found, the court will declare you a proclaimed offender. There are procedures after that, what you do. You publish notice, you go attachment for the property, all this is there. But now, and never there was a procedure to continue the trial against him, because it's unheard of in any country in the world that in absentee of the accused, you are going to try him and convict him. And they say that all the evidence will be considered. How? We don't know. Who is the lawyer going to take instructions from? If the accused is there, not there, we don't know. And it is very easy to convict somebody like this. The police has to just come and give a report saying that this accused was not found. And the police will, and the court will say proclaimed offender, and they will continue with the trial. Suppose he is somebody from Konkan. He has gone to Konkan, he has locked the house here and been in village. Police is not going to bother to find him, go and find him in Konkan. They say, मैं घर जाके आया, बंद था घर. Proclaimed offender, trial will proceed and he will be convicted. Something which is unheard of, extremely dangerous. Activists shouldn't leave their houses. I feel. because otherwise you will be all proclaimed offenders. There is something new to it. And again, as Brinda said, there are many things they have done which go against what already the Supreme Court has laid down the law, and there are many judgments to that. There is a provision, again, when they come with these numbers, nobody has any idea, nobody has any logic. We also trying to understand why would they have done this. Any complaint, cognizable complaint, which is punishable between 3 to 7 years, if you have a complaint, and these are many offenses, right from stabbing, slapping, sexual assault, there are several offenses under POCSO also, which is a Sexual Offences Act against the children. So you go to a police station now from 1st of July. Today you can still go. But if you go after 1st of July, they say the police officer, that is the SHO, station house officer, can decide prima facie whether there is a case or not, and then he can decide whether to file an FIR or not to file an FIR. This is extremely dangerous. First of all, now they are putting the police in the domain of judiciary. Whether a prima facie case is there or not was completely with the judiciary to decide. Police can't decide the prima facie case. The courts had continuously said police has to register the FIR moment there is a cognizable offense, and they cannot do anything more than that. Even then they wouldn't file an FIR, we would go to court regularly. But now you are giving them a free hand. This is open to corruption. This is open to many other things that can happen. And we know how the police function in this country. FIRs of marginalized people will never be taken if there are petty offenses. You are basically saying, you get murdered and come to police station, I will take your FIR. If you are slapped, you are stabbed, I am not going to take your FIR because it is meri marzi hai bhai. Main lunga, nahi lunga. It is all now what that movie was. Simba. Singham. So every SHO is now given a right by law to be Singham. Whatever he can do is the law. There is a very another interesting provision, and even Dolphy should be worried about it. This thing. They say that any place can be declared as a jail at any time on the recommendation of the central government or the state government. So suddenly state government says we are all in jail here, we can be kept here. But this provision will be very useful for all the resorts after the Maharashtra election. The MLAs will be kept there, and then they will say, till you sign with whoever you support, till that time this is a jail, because the Maharashtra government has declared it is a jail. There is no logic again. Why would you say that any place? What is the meaning of any place? Please think of Kashmir, what they did. And this is what they are trying to do to the entire country. They declared theatres, movie theatres as jail. They declared stadiums as jails, and they put people there. This is what they are going to do. And they are putting these provisions very silently in these things. When they say we have done a copy-paste job and there is nothing else, these are the things they have introduced. From draconian laws, they have brought into the normal laws, which is extremely dangerous. One of the other provision which is still debatable, I would say, little bit, I don't know, there is no logic still, but debatable. This thing, accused can be heard at the time of complaints. That is a private complaint, not FIR. So what my thinking is that the accused will be called and heard, and the judge may dismiss the complaint saying that I believe in the accused or I don't believe in the accused, and continue with the complaint. But this is going to repeat the process, because the accused is, even if the process is issued against the accused and he's summoned as an accused, he's not going to stop there. He will go to the higher courts, as that is his right. There's nothing wrong with it. So I don't know why, when they say that we want to speed these things in courts, when they are creating these hurdles, there's repetitions which will happen in several courts, when the infrastructure of the judiciary is very, very abysmal in this country. People should just to have an experience, go to Bandra Magistrate Court and see how the court functions. and Kurla Magistrate Court, how the court functions. I'm not batting for AC courts, I'm not batting for luxurious courts as Ahmedabad has seen it. But, but I'm just saying, give the basic infrastructure. One public prosecutor is divided between 4 magistrate courts in Bombay. One steno is divided between 4 magistrate courts. No orders are passed. And then you are creating this kind of system where it is just going to create a whole lot of mess. There is another very interesting provision where basically any complaint against a police officer, which they say whatever he does in the course of his duty is going to be as good as impossible. Even today, to prosecute a police officer is a Herculean task because you need sanction. And only if a sanction comes, then you prosecute. There are hundreds of judgments used which say that it is very difficult to get witnesses against police officers. But there have been convictions. Some of the convictions the Vrinda has got. It's, as I said, it's a Herculean task. But now, if the FIR is not registered, what do? You go to the SHO. And that SHO will say, ये 7 साल के अंदर है तो मैं नहीं लेता है. But if it is more than 7 years, we'll say इसको मारा है, मर गया है, murder लगाओ. I keep going back to 302, forgetting it won't be 302. I'm sorry. I have to learn the new section still. So, the complaint may be taken. So, he will have to go to the magistrate to file a private complaint, which in today's case was a very normal thing. If the police doesn't take an FIR, you go to a magistrate and file a complaint against the police officer. Magistrate will say, bring all the witnesses, I will issue process. And then the rest of the thing of sanction may continue. At some point of time, he may say that sanction was not required because this was not part of the duty. But today, the 2 big hurdles which they have created for a complaint against a police officer is that once a complaint is filed before the magistrate, the person against whom the complaint has made, he is to be issued a notice and he has to come with a report saying that whether it was in course of his duty. I have committed a crime and I have to go and admit that I have committed a crime. If he agrees that it was not in course of duty, then the SHO or the superior officer of his has to come and give an affidavit saying that this all happened and it was not in the course of duty, hence prosecute him. Please tell me which police officer will be prosecuted in this country by private complaint.
Yes.
Nobody. And this is another sinister thing they have added. Please keep always Kashmir in mind when I am discussing this. This has all happened there. Now, another thing, they say that they are making it for Indians, but they are taking away all the rights. As simple as mercy petition after death to be done in 30 days. I have no understanding why this is done. There is no logic. It is as good as ridiculous. Many times the order of the Supreme Court doesn't reach the jail for 6 months. I'm not joking. It is 6 months the accused doesn't get the order. Then they say mercy petition can be filed only by the relative. It's because Vrinda filed too many mercy petitions. So if I don't have a relative and I don't file a mercy petition, I will be hanged after 30 days. And you know, if somebody looks at the mercy petition jurisprudence in this country, they have been filed after a long time. They take a long time because you need to get so many details of the person. Go to his villages, find out how was his upbringing, what happened. There are so many factors that go into a mercy petition. And secondly, anybody should be allowed to file a mercy petition. You are feeling wrong that somebody is being killed in your country, you should be allowed. Why should that right be taken away? And I'll also tell you why relatives may not be interested. He might have property.
Yeah.
And relatives say, मरने दो, उसने offense किया है. And many of the death penalty cases are out of property, are out of crimes against women where the family do not want that person to be with them. And then you have created these hurdles. There is no logic to this, why only a family member can file a mercy petition. This has happened in some of the states. We have opposed it. I don't know how Justice Chandrachud says, I'm welcome to this. I don't know whether he has read it. Because there are contrary judgments of his from Bombay High Court. But trial by video conferencing is something which he opposed as a judge. And he said, by video conferencing, only remand can be done. I have an order, I'm not talking. Justice Dalvir Bhandari's and Justice Chandrachud's order, which was written by Justice Chandrachud. And now there is trial by video conferencing, which Justice Chandrachud says that this is all welcome. I'll tell you the trick of video conferencing. You can hear nothing in the court. Please come to Sessions Court in Bombay. You don't get even the range. When he talks about digital courts, I want to tell him that please get us internet in Sessions Court first. And then we'll talk about digital courts. And what if suddenly while cross-examining, accused has to give instruction to the lawyer, and that the entire court, all the judge, whoever the judge is, whoever the prosecutor is, will hear the instructions. So it is completely goes against the grain of criminal law, goes against the rights of the accused, and hence trial by video conferencing is something which should be opposed in total. State has taken your custody. It is the duty of the state to produce you before the court. It's as simple as that. You cannot give excuses. Today आज बंदोबस्त है, आज गाड़ी नहीं आ रहा है, आज मेरे पास पेट्रोल का प्राइम मिनिस्टर ने रेट बढ़ाया है, इसलिए हम गाड़ी नहीं चला सकते. You can't give these excuses. I'm sorry, you have taken away my right. You're putting me in Taloja jail. You please take me to the court and do the trial. Very dangerous something is something, commutation of sentence was completely within the domain of the state government, because law and order at the end of the day is a state government subject, and state government can decide whoever sentence they want to commute. Of course there are guidelines. It is not that they do it randomly to anybody. And so the earlier, in the present CRPC, it said in some of the cases in consultation with the central government. Now the word consultation has been taken out, and they say in concurrence with the central government. This is also with a dream that they will never leave that central government. They think that they will always be there. Because otherwise they wouldn't do such a thing. But it's also dangerous to federalism. Why is something which is a state subject, they will every time go begging to the central government to give us the permission to commute the sentence or not commute the sentence? And what if the state government doesn't want to commute the sentence and central government wants to commute the sentence? There are a lot of examples. That is a rape case from Rajasthan. Central government will say commute the sentence. But now they have both the governments the same. Double engine hai wahan pe abhi. And people who are doing intermittent fasting, please be careful. While you are intermittent fasting, don't say you're protesting about something, because you can be arrested. You just say, I'm doing intermittent fasting. Don't attach it to any kind of your philosophy or politics. Because as Vrinda said, hunger protests have been criminalized. Today, it was intention to how do you criminalize Gandhiji. So this is what they have done. And I will conclude finally, we can take questions. But the final and the very funny thing they have brought in is community service. Again, there is no definition of community service. We have seen in recent past what happens with community service. You take a posh, go and kill somebody, and then you, as a community service, you have been asked to write an essay. So this will be the community service, which has happened already, and you introduce it. Sardarpura accused also. There have been many instances. In rape, accused has been asked to tie a rakhi around that woman. This is community service. So this is extremely dangerous laws changes we are looking at, I'm only reminded of two things. That the German poet, which we all know, that they first came for the communists, we didn't speak and all that. But now, finally, they're coming for us. They've come for the chief ministers. Nobody has said anything. They're finally coming for everyone now. Please be careful about this. Know this. And when 370 was repealed, lot of our friends said from Kashmir and outside, the intention is not to bring Kashmir into India. The intention was always to make entire India Kashmir. And these laws are the process to start making India a Kashmir. Thank you very much.